Thanks, Julia, and thanks all for giving up your lunch break to come along and talk about contracts. That's really encouraging for me as a bit of a contract nerd. Hopefully you'll learn something new today. I'll hang around for a bit afterwards as well if anyone wants to have a bit of a chat or have any questions. I've got a fair bit to get through, so unless there's something particularly burning, maybe just let me wrap it on. Obviously, Julia and Nadia and others in the room play a key role in all of this as well. And if I say something that they don't agree with the way they do things at their institutes, I'm sure they'll speak up and let me know. So that's the mug shot, I will skip over that. What we're going to cover today, very briefly set the scene for particularly, were most of you at the second lecture on IP and what it is? You've got a bit of, I'm seeing some nods. Okay, that's great. I'll just very quickly set the scene around IP basics, and the contracts around commercialisation really build on IP as being the central focus of those contracts. Look at how that all fits into the tech transfer process. Some specific considerations for IP related contracts, and then, some contract law basics 101. Just so you know, and then focusing on non-disclosure agreements, material transfer agreements, research agreements, and if we get time at the end, some general things applicable to contracts generally. So if you were here at Seminar 2, you'd appreciate how intellectual property is how your scientific and your creative input and work is protected, and it's the tool that's used to take that intellectual output and use it to have public good, through commercialisation, development into products, through all sorts of different ways and means that you can use to commercialise. And because it's a property right, it can be bought, it can be sold, it can be lent or hired, or the technical term is licensed. And the one of the beautiful things around intellectual property is because it's intangible, there's a lot of flexibility in how you can buy, sell, license IP. You can license it to one person, you can license it to 1 million people, you can split, dice, carve it up different ways. And it's also obviously a key part of how you facilitate collaborations and engagements with other institutes and commercial entities. So again, to recap, different types of intellectual property, key things that I'll probably focus on that are relevant for you guys are patented technology, and particularly confidential information, know-how, trade secrets. A lot of that is really relevant to information and materials that may or not be subject to patents. There's obviously copyright and different forms of IP as well. So, Contract Law 101. Excellent. Basically, when I'm talking about a contract, and agreements and deeds are forms of contract, there's some slight nuances, but contract, agreement, deed, pretty much one and the same. What it is, an agreement between two or more people or organisations that creates legally binding rights and obligations. Not just morally, but legally binding. And the consequence of that is that if those obligations aren't met, there can be some quite significant consequences. You might have a contract terminated and your rights terminated. You might be faced with a lawsuit for damages suffered by the other party, or an injunction, which is where the court says, look, stop, no more, you can't do this legally. And if you do, you can end up in all sorts of trouble. The key things that they're useful for are for managing risk, and particularly reallocating risk from where it might otherwise fall from one party to another. Useful for distributing rewards. If I'm giving you materials, I'm letting you use them to create a product, you'd otherwise be entitled to keep all the benefit of that, but I might have given you the right to use those materials on condition that I get some royalties or other payments as a result of letting you use my materials. So we're sharing the rewards back, those rewards being useful for funding further research or activities, that kind of thing. One of the things that I find contracts really helpful for is just setting expectations, particularly at the beginning of a a collaborative or a commercial relationship. Yes, the process can be a bit painful sometimes, getting a contract in place. You've got to negotiate and have hard discussions about difficult topics. But when you're getting married, you have those hard discussions about all sorts of things before well, hopefully you do, unless you're rushing off to Vegas after a few drinks. But, you have those discussions. You ideally make it written and clear as to what your expectations are from either side, and to reduce the likelihood of disputes down the track. And a lot of the benefit, I guess, in having formal contracts is just really cutting down the risk of disputes and falling outs and misunderstandings down the track. And sometimes you actually need them because there are legal requirements. To sell a house, you've got to have it in writing, signed by both parties. Intellectual property is the same. Most of the intellectual property legislation says you cannot transfer ownership of a patent or copyright or so forth unless it's in writing and unless it's signed on behalf of the people selling those rights. So, there are often some quite technical legal reasons why things have to be documented or documented in a particular way. Contracts don't have to be, 50 pages long, signed, sealed by the CEO or the director, that kind of thing. They can be informal. It might be an exchange by way of emails, may still create a legally binding contract. A conversation, just verbal, oral, may still create a contract. Typically, by unilateral it means I can have obligations just on myself. I'm agreeing to do certain things. You might not be agreeing to do things in return. Bilateral, you might just have two parties, organisations. Multilateral agreements, if you've been involved with the Cooperative Research Centre, you might have 15 parties to that contract. And some of the multi-institutional agreements I've seen, good fun when you've got dozens of parties to that. Typically, to be binding, there needs to be an intention to create legally binding relationships, and then you come into some issues around memorandum of understanding, letters of intention, term sheets, that kind of thing, which are typically non-binding. Sometimes they are really useful in serving a purpose, particularly for larger, more complex collaborative or commercialisation deals, but not a shortcut to doing a proper contract. And there are circumstances where they actually are more harmful than good. If you're ever unsure about any of this stuff, sorry, I should have said at the outset, please do speak to Nadia or David or Julia, who will know exactly what form of contract to use, or they'll get advice if they're unsure themselves. So why do I need them? Again, this is based on a slide I think you guys had earlier on. The certainty, being clear on who's paying what, who's doing what, by when. People move on, people move around. You might know what your collaboration is going to look like, but a year down the track, key players may have moved on. So the contract is that clear understanding and that certainty of what's expected. Bit of an insurance policy if things go wrong. Sometimes things go wrong, it's no one's fault. The contract should deal with a lot of the consequences in that case. Or if someone does the wrong thing, who's responsible? How do we deal with that? For research contracts, if there's an external grant, there will invariably be a requirement that requires you to have all of that research with other collaborators documented, and often quite prescriptive in how that is. So there may actually be legal requirements, funding conditions, that kind of thing. Like I said, clarity around intellectual property ownership, rights of use, restrictions and freedom on publications and data sharing, that kind of thing. The contracts play a key role in setting out how that's going to work and who's entitled to do what. Again, to help, sometimes because it's a legal necessity, sometimes to reduce the likelihood of disputes. So from the previous slides, this is your fabulous tech transfer process here, right from pre-disclosure through to getting the deal done at the end and managing that deal. And contracts come in at different points of that. So again, from one of your earlier talks, at the pre-disclosure stage, typically you'll be looking at confidentiality agreements, non-disclosure agreements, different words for basically the same thing. Material transfer, research agreements, sponsorship. We're going to touch on some of those in a bit more detail. Again, at this stage, if you're collaborating externally, please speak to your commercialisation team sooner rather than later. For their sanity and for everyone else's, don't pop into their office that morning saying, oh, the courier's arrived, I've got to ship this biological material across to the States, I need an MTA at the 11th hour. The sooner you engage with them, the easier the process will be. Legal agreements will often pop up again at the protection stage. You think you've got an invention, the patent attorneys say, woohoo, we think you do too, let's go file a patent. Ideally, you'd already have your collaboration agreements and your interinstitutional agreements sorted by then, but often not, and occasionally with long-term collaborative research arrangements, you might agree to do specific agreements around particular patent filings at the time. So at that point, you'll reassess that, and again, some of those other contract types might come in there. And then we won't really touch on this today, but obviously at the commercialisation, the external deal stage, very much the contracts are a central and key part of that. And the three most common types of agreements for commercialisation are the licence, where I own the IP, I'm going to give you permission to use it for cancer, I'm going to give you guys the right to use it for heart disease, you've got to do certain things with that, achieve certain milestones, regulatory approvals, etc. In return, I'm going to get a cut of the profits you're going to make from my amazing technology. But if things don't work out, well, then I've got the ability to terminate, to end the licence, go find someone else that will commercialise it for me. Assignment is the technical term for selling, transferring ownership of an intellectual property right. So I've got this amazing patent, look, I really don't care, I'm not that interested in it. You want it, you can buy it. Again, might be for a single lump sum, or there might be ongoing payments and royalties based on sale. An option is kind of like an interim step, saying I'll agree to license or assign to you, but on condition that some other steps are met. So typically the commercial party might want to do some further R&D work or some further trials to work out whether the technology is actually going to do the job, and at that point they'll make the decision whether or not they're going to have the licence or the assign. And just one thing to keep in mind as a researcher, if you're collaborating with particularly commercial entities, just don't make promises at the very early stage about potentially assigning or licensing or that kind of thing, because it can create issues commercially and on the relationship level, but it can also create some legal issues if you've been making promises and representations that you can't keep later on for whatever reason. So contract law basics. Yes, I've touched on a few of these things. You obviously need to be agreed on what the key terms of your arrangement are. There needs to be some certainty around that. There needs to be all of the key aspects need to be agreed and complete in that sense. Consideration is a legal word for an agreement. Both sides need to be giving something, whether it's cash or whether it's doing in-kind research or something of benefit flowing either way in order for there to be a binding agreement. The one exception to that is if it's in the form of a deed. So that's, I guess, a formal legal thing you can do to get around this other requirement that there's actually something of value being exchanged in order for it to be legally binding. You can do a whole university year-long course on some of this stuff, but just to make the point that the terms of the contract, which is typically the content and the rights and the obligations, they might be expressed, they might be what's written down in the contract, but there's also what's called implied terms. So typically there might be a statute, sometimes international conventions that imply contractual legal obligations in certain circumstances, and a particular one is the sale of goods. So if you are shipping materials to someone, there's payment changing hands, you might, as the supplier, have a whole lot of implied obligations, and there's a whole lot of implied obligations around fitness for purpose and things to do with supply of goods, which kind of makes sense if you're selling vacuum cleaners, but make no sense if you're supplying experimental biological materials, that kind of thing. So those implied terms can often be excluded or limited by a written contract. So again, one of the key reasons why we bother with MTAs, it's not just to create work for the lawyers and the commercialisation people, that there's actually good legal reasons there for those. Just a key point with the contracts is they can only be between legal entities, and in your context that's often not the easiest thing is to work out who the legal entity is. You've got legal entities in institutes and some informal collaborations that aren't legal entities. You have people with conjoint appointments. They might be employed by a university or a health network. Do both of those parties need to be signatory to the contract, just one of them, that kind of thing? Again, that's something that the commercialisation team can help you work through. But when you're dealing with an external party, it helps them if you can tell them right up front, who are we dealing with? Is this researcher, like he's got a university email address, but is he actually employed by the hospital? In which case, or is he employed by the hospital but the university is supplying the lab where the research is going to take? Who actually do we need this contract to be with? And that's a threshold issue that it's helpful if you can support them. And typically, again, only the parties who've signed up to the contract can enforce it, although there are some exceptions in some countries and even some states here. Something to keep in mind, just because someone else has a contract and it says that you've got rights, you might not actually be able to enforce that. So if you want rights, better to have the contract yourself with them. Again, when dealing with any of this stuff, be aware what your organisation's delegations policy is. Typically only certain people are authorised to sign non-disclosure agreements, material transfer agreements or the like. It might depending on various circumstances. Researchers will often be asked to sign particularly material transfer agreements. They may or may not be signing as a party to that contract, but they might just be signing to acknowledge that they've read and understood what their obligations are. But often researchers may not have authority to bind their organisation. So again, if you're receiving materials from an external organisation, the associate professor you met at the conference has signed both on their own account on behalf of the organisation. It may be worth checking, did they actually have authority to sign? That template MTA they've just downloaded off their website, that kind of thing can create issues, so just to be conscious of. How am I going for time? past. Excellent. Sorry, I'm talking very fast. Do people want me to slow down a bit? No? Okay, good. So just a few things specifically related to IP contracts to keep in mind, and again, essentially looking at what contracts are. You're looking at the inputs that both sides are putting into the relationship, the risks associated with the relationship and the activities, and what the expected outcomes are. And those different inputs and inputs and outputs will have different weightings. So in IP contracts, obviously your existing IP, how your skills, data, often it's the people, that are one of the key inputs. And obviously, financial, whether it's direct cash or provision of facilities, that kind of thing. Again, different qualities, different importance for different relationships. But when you're coming to a contract, keep in mind, who's putting in what? Where does it weigh up? The actual content of the contract is probably going to vary quite considerably depending on whether you're mostly receiving stuff or mostly putting in, and the lawyers assisting you can do a much better job of assisting you if they've got an understanding of some of these bigger picture things. what are the risks? The project doesn't work. They take your IP and misuse it without compensating you. Potential reputational issues. You can manage these things by due diligence. That's the term for doing your homework on who you're doing your homework on their IP assets. If you're in licensing IP, being educated. That's why you guys are all here, which is great. And to some extent you can protect it by things, warranties and indemnities. A warranty is, a representation that you typically make formally in a contract. It's, I own this glass of water, it's mine, I can give it to you, that kind of thing. Now, if I don't actually own this glass, because I don't, it belongs to you guys, then if I purport to sell it, they can't, they're not the legal owner and so forth. And so then they could sue me for breach of warranty and I'd be liable for coughing up for the damages, $2 or whatever a glass of water costs these days. Indemnities, again, that's a legal term for where risk is shifted from one organisation to the other where it might not necessarily sit. So if I give that glass of water to Julia, turns out it's got all Giardia in it or something nasty, she gets really sick, she'd be responsible for her doctor's bills. But if I've agreed to her that I'll indemnify her for any loss or damage that she suffers as a result of drinking my glass of water, then I'd be responsible for her doctor's bills and probably a lot of grief. So again, yes, some of the outputs. What are you expecting when you're entering into a legal arrangement? What are you expecting the outputs to be? Being clear on, is it cash? Is it IP? Is it a bit of both? Is it more facilitating a relationship and getting people together, that kind of thing? And being clear on, what your expectations are, what happens if they don't align, and that again, whoever is assisting you with that contract will be able to do a much better job of giving you a contract that's going to be useful for you to align with what you're trying to achieve. So we've touched on some of the different types of contracts. Non-disclosure agreements, confidentiality agreements are typically preliminary agreements to something more substantive. Not always, but they're not the be-all and the end-all usually. Material transfer agreements, sometimes it's tempting to kind of squish a collaborative research project into an MTA because they're shorter and they're easier to get signed off, that kind of thing. That can create all sorts of issues, potentially because they're shorter, they don't actually deal with all the important stuff that you come up with in collaborative or contract research. You can have prototype development agreements, evaluation agreements, licences through to the full joint ventures and cooperative research centres, which may involve setting up a new company and having shareholders agreements and all sorts of things, and licences and research arrangements around all of that. That's very much more at the commercialisation stage. But as you can see, a wide variety. So non-disclosure agreements. Look, if you take nothing home, they're great, they're useful, they serve a purpose. But one thing to remember with confidential information is once it's been published or it's leaked, there's very little you can do about that. So if the value of your IP is in its confidentiality, by all means have the best NDA that you can, but take practical means as well. Password protect things, be careful about who you share things with, where you store it on the computer systems, all of that kind of stuff. And don't forget to, particularly dealing with commercial collaborators, put confidential in the footer of things, all those practical steps are really, really helpful as well. Key things in non-disclosure agreements is working out, what's actually protected by that agreement, and that whether that's broad or narrow will depend on whether you're the one disclosing the information or receiving it, or whether it's going to be 50-50. Do you want to kind of cast the net extremely broad? Any information, unless it's part of some narrow exceptions, or be really clear to say, look, it's only this type of information and it's only if I actually put confidential on the document, that kind of thing. There's usually a number of exclusions, so anything that's already in the public domain is typically excluded from definitions. If someone already had it in its possession lawfully from somebody else, or if they come up with it themselves without kind of reference to information, that's not normally stuff you can protect. That's fair game. And the NDA will normally prohibit you from disclosing it, whether that's through a presentation or publishing it on the web, or using it incidentally as part of a patent filing that might get published down the track. Typically they'll also have restrictions on use. What can you actually use this information for? Is it only for this particular purpose? And what happens if you go beyond that? So a key aspect with your NDA is defining, well, what is that purpose? What can they use that information for? So again, when you come into your commercialisation team, I need an NDA. Come to them being clear on what information is going to be subject to that. Is that going to be broad, narrow, somewhere down the middle? And how big is that defined purpose? If you're receiving information, obviously the broader the purpose, the better. If you're giving it away, you want to keep it narrow. And there'll always invariably be exceptions for compulsory disclosure. So if there's a court order or legislation requires you to disclose something, and for health-related information, there's often laws requiring disclosures in certain circumstances. And dealing with any government authority or body, the minister always has a right to know what's going on. So you'll often see exceptions for responses to requests from ministers for information, that kind of thing. So there's extra bells and whistles you can add into NDAs if you want. You might control disclosure to, okay, only this scientist and people in her or his lab. You might put restrictions around. One of the interesting ones is where you might have put a lot of effort compiling public information. So that information in that compilation is all little bits and pieces of public information, but you put so much effort into that compilation, you want to keep that compilation itself and treat that as confidential information. So being explicit about that. Again, if you're disclosing valuable information, do you want some restrictions around any new intellectual property that the recipient might create using your information? Some rights to results that they might use if they're using your information for other purposes, that kind of thing. And then some restrictions around liability. Again, if you're providing information, you don't necessarily want to be legally liable if it turns out there were errors or gaps in that information. So the NDA is a useful tool for protecting you there. Again, the key definitions are what information's included and what's the purpose is there. One other thing is, what about notes and summaries and extracts that the other party might take of your confidential information? Is that going to reach through to those notes and summaries as well, and vice versa, or just the original information? Time limits. In Australia, you can have a confidentiality agreement continue forever. Typically you will see a 3, 5, 7, sometimes 10-year term, depending on the type of information. But again, what's this type of information? If it's financial information about a company's annual turnover or whatever, like 3 years might be more than enough for it to keep it confidential. If we're talking biological materials, you might want 10 years. It's potentially a long duration. So what's reasonable? Again, this will depend on the type of information, whether you're receiving or disclosing, but certainly something to feed back to whoever's helping you with the contract. There can be some sneaky things. I like to put in sneaky things sometimes into my clients' confidentiality agreements regarding reverse engineering of information, IP they create using it, that kind of thing. Potentially some of those grabs can be quite broad, so being alert for those. And again, disclosure, if you're dealing with a large company, what about its affiliated companies? What about their contractors? Is that allowed, or are you going to have some additional control on all of that? And right through to, if it's particularly sensitive information, you can be quite strict and say, look, you can only disclose it to these named employees. Each of those employees has to sign a personal confidentiality agreement. You've got to give us copies. You've got to have audit trails of where the information goes, that kind of thing. So material transfer agreements, basically non-disclosure agreements, but for physical materials as opposed to information. So confidential information, again, not really that great for dealing with physical stuff, other than, I guess, physical hard copies of written information. But material, biological materials, prototypes, samples, anything like that. An extra layer of protection dealing with the fact that it's physical. Oops, wrong button, there we go. So this is CMRI's standard MTA for ProCan, where they're receiving information, receiving material, biological samples, that kind of thing. As the recipient of information, so materials, these guys don't want too many restrictions on what they can do with it, as long as it's within the general ProCan purpose. On the flip side, this is the New South Wales Health Standard Agreement for the contribution of samples collected from the health system to biobanks. Now, if you're providing materials, you probably want to be quite strict on what the recipient can and can't do with those. So again, there's a lot of shades of grey. There's no such thing as a standard MTA. It depends on whether you're receiving or disclosing material. If it's going both ways, then you have to find a happy medium. One of the key purposes is to be clear on what happens with the physical samples and to control where they can go and not go and what they can be used for. There'll be some things around liability. Again, if those biological samples happen to be infectious or something like that, who's responsible for that? Intellectual property is often a key thing in these agreements. There may or may not be intellectual property rights in the materials being transferred, but they may well be new intellectual property rights created from the use. Who owns those? Who has rights to that? Who controls publications around the results, that kind of thing. So you'll often see a bit of argy-bargy around what's included. So materials are typically what was supplied. Progeny for biological materials, there's cell line producing cells, they're unmodified, they're the same. They would often be treated the same as the original materials. Then you get unmodified derivatives. So you might have DNA extracts, something that's been taken out of the original materials but isn't the materials as such. And then modifications and modified derivatives, where genetic modifications are happening, people are playing with material. Does the original provider own all of that? Own it in the physical sense and own it in the intellectual property rights in those as well? Or do you draw the line somewhere in the middle there and let the recipient, say, for example, keep the modifications, vice versa? And again, this will depend on the materials, the circumstances, who you're collaborating with, whether they're commercial or academic, all of these things. So think about these issues early on. Make sure that, you've got the bigger picture in mind. You're not just shipping things across without too much thought. So again, the use, the purpose, what's the permitted use? That's going to be a key definition in your MTA. Your publication and sharing of results, that's obviously a key thing, particularly if you're shipping materials for free to an academic collaborator. What are you getting in return? Is it just the mere acknowledgement in the publication that you supplied the materials, or do you actually get a right to access the data as well and use it for your own research? Ethics and privacy is a big one when we're talking about human and also animal tissue samples. Do they actually have ethics clearance and informed consent for those samples to be shipped to you? If you're receiving that, that's certainly something you should be checking off. And again, if you're agreeing to transfer samples to a third party, do you actually have ethics clearance and permission to do that? Nadia's nodding her head. And certainly with you guys, some of you would be dealing with this stuff on a day-to-day basis. Yeah, and again, the argument is around, what happens around derivatives modification. And also data, data is an interesting one. There may not be intellectual property per se in the data, but it's still valuable. So let's address that. So research agreements, very broad term. These take all sorts of different forms, from your pure collaborative research, where each party's bearing its own costs and putting some in-kind in, through to fully sponsored research by a commercial entity. It also covers potentially clinical trials, consulting services, and various things in between. So again, one of the key things is who's doing what, who's putting in what, who's responsible for what along the way, and who gets what at the end of it. These are some of the typical arguments you have, particularly with commercial entities involved in collaborative or sponsored research. They'll say, look, I'm running you a big fat check. I should own everything that comes out of it. Thank you very much. On the flip side, they're coming to you because you've got expertise and skills and training that's valuable. They don't have. You might be shortcutting some internal R&D that otherwise have to pay a lot more for. Don't sell yourself short just because a commercial entity is funding. So, being clear on what rights are they getting out of that. And again, they'll often say, I'm writing you a big fact check. I'm used to getting what I pay for. You're a scientist. Science is uncertain. You don't know it's going to work until you've run the experiments. So from a legal perspective, being clear on what you're actually promising to do and achieve. And typically we'd say, look, we agree to run the experiments, and we're not agreeing to achieve any particular outcome. This is what we're aiming to achieve, but if for some reason it doesn't happen, don't sue us. And another thing to keep in mind is, I'm probably more from the commercial collaborator side, but if you're doing the arrangement because of key personnel, is that something that you lock into the contract? These researchers need to supervise the research, or we don't really care, we think you're all great over here. On the flip side, if you've only got one researcher that could possibly do this work, what happens if they up and leave, or they become ill for an extended period, that kind of thing? What kind of protections have you to make sure you're not stuck with a legally binding contract to perform some research, but you don't have anyone with the skills to do it? I've just been in a meeting this morning, again, looking at a research plan next to a contract. It's a great research plan. It was based on a proposal done for a commercial entity. It's fabulous, but it was written as a proposal for a commercial entity, and it has all sorts of wonderful things in it. But I now need to annex that to a legally binding contract, and that research plan sets out not just what the research is and who's doing what, but it defines what IP coming out of that work is owned or licensed to the commercial entity, and potentially royalties and significant milestones and all sorts of things. So we can't just clip it on the back and hope for the best. That's actually a really key essential part of the contract. So for those of you who are asked to do research plans or look at schedules to contracts, please take the time to do that. The types of plans you write for funding proposals and grants aren't necessarily in a form that's great to be legally binding, because we all know how you write funding proposals, right? It's a very different purpose. So just something to keep in mind. Again, if you're looking at milestones and deadlines, are they realistic? Have you given yourself some wriggle room there? A commercial collaborator typically won't like giving you a blank check just to go and do whatever you want in the lab for a year. If you're lucky, they will, but usually not. But are the milestones that you're committing to, are they realistic and achievable in light of everything? And if things go wrong, does the contract give you some leeway there? The precedent clause, that's the bit in the contract that says, look, if the research plan says something that's inconsistent with the body of the agreement, and keeping in mind the research plan might change every 6 months as you reassess things over the course of the contract, which one's actually going to take priority? Is it the research plan or is it the formal contract? It might be either, depending on the arrangements, but just being conscious of, if you're tinkering with the research plan, does your contract also need to be updated, or vice versa? And with all this stuff, I mean, I think most scientists are pretty good, but the details do matter with these contracts. Often disputes around IP can come up many, many years down the track, and often it will be the detail that's important. So it is worth putting the time and effort in early on when everyone's friendly, rather than having to deal with a situation down the track where there's a disagreement and no one's got the will to do anything to come up with a practical outcome. So key issues that we've talked about, the project plan, like being a critical part. Having a project director and a project committee, really useful way for longer term relationships to keep them on track, whether it's a collaborative arrangement or a commercialisation one. Look, if things are going well, you don't have to meet every 4 months, 3 months, but it's a useful tool if things are starting to go a bit off the rails, that you can make sure that you are having those meetings. With financial stuff, are you getting paid quarterly in advance? Great. Or do you only get paid once certain activities have been completed or milestones met? Commercial parties and funding bodies will invariably want often separate accounts and clear audit trails of how their funds are being spent. You've got someone else's money, you need to be accountable for that. So again, if you're performing one of these contracts, make sure you're aware of what those obligations are and you're fulfilling those. And again, around intellectual property, being clear on what's in scope of the agreement, what's not, when might you have to share some of the benefits if you make commercial use of it down the track, that kind of thing. Let's just skip over. This is just an interesting one. Just when you, particularly with commercial entities, so we have got an option over there. Well, we might own the outcome, we might have a licence to the outcome, or we might have an option. And that means different things to different people. An option in the legal sense is something legally binding. If X, Y and Z happen, then you get the licence or you get the assignment. That's it, done. It could just still be a right of refusal. So you agree not to give it to someone else unless you've offered it to your collaborator first. Or give them the right to match terms that a third party is. And I guess at the lowest level, it's a right of negotiation, or an obligation to have good faith negotiations about what the commercial arrangements might look like, but nothing legally binding that forces you to assign or license the IP. And again, there's always lots of argy-bargy about where the risk falls and who's responsible for what, particularly public sector research institutes. You don't want to be taking on unnecessary liability if you can help it. So there's usually a bit of back and forth on that bit. Excellent. So contracts generally. Some things to keep in mind, what the duration is. And I guess term in the sense of duration as opposed to the terms of the context. Your research program might only run for 2 or 3 years, but some of the obligations around confidentiality and IP may have a longer run-off period. So again, being aware of those and having a think at the outset of what's too appropriate there. Termination, when can you terminate? Is it only if someone hasn't performed and failed to fix that issue? Is it when the commercial party's gone insolvent, or do you have the right to terminate at any time without having to give reasons? And if the commercial party wants that right, is that long enough that you can deal with any cost you've incurred, whether it's for consumables or staff or that kind of thing in the meantime? Assignment and subcontracting. So assignment, again, in the sense of the contract, means transferring the obligations under the contract to somebody else. Can that be freely done, or are there some restrictions around when it can be transferred? A commercial party will typically want the right to transfer the contract if it sells its business to somebody else, that kind of thing. As the research provider, you might not be able to assign or subcontract at all without their consent. If you're likely to want to be able to do that, make sure you've addressed that up front. And boilerplate, that's the term for the boring stuff at the back that the lawyers usually gloss over as well, I must admit, but there's often potentially really important detail in there as well. So if you've been asked to review a contract, read that stuff at the back. If something doesn't make sense or doesn't sound right, put your hand up, ask the question, because better to do that before the thing gets signed rather than when there's an issue down the track. One thing that is really important is to, once you've got your contract, not to just shove it in a drawer and forget about it, that contract sets out legally binding rights and obligations. So make sure that the key players are aware of what they are. If there's an agreement in the material sample agreement that you have to make sure that the materials are kept in a vial that's labelled, subject to material transfer agreement dated blah 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 with such and such. Don't just tip that stuff into another vial and put it into a separate fridge. Make sure you're aware of those practical obligations. Diarise deadlines. If you've received potentially valuable information but you've got a 2-year confidentiality restriction on it, put the date in your diary when the 2 years are up and you're free to use it. There's no reason why you can't do that. And again, particularly if you've got deadlines in research contracts, whether it's to receive money or to do certain things by, make sure you're on top of all of that. Every organisation has different ways of managing contracts, particularly on the type of contract and what have you, so make sure you're familiar with those as well. And the role that you play as a researcher or wherever you sit into the scheme of things. And to finish on a cheerful note, humans are humans. We wouldn't need contracts if everybody just got along and were agreeable and could resolve all their problems by growing up mature discussions. So, contracts are helpful when relationships break down. If you've done a good job in addressing the key issues, they might provide a process for you to follow, hopefully. So termination is obviously a key one. When can you terminate? How do you go about it? There'll be quite detailed processes. If you're ever in a situation where a relationship has broken down and there's a contract, please just don't say, oh, it's all over, forget it, walk away, because there are actually legal consequences if you purport to terminate a contract and you're not legally entitled to do that. So please go speak with the relevant people before doing anything of the sort. Force majeure, again, that's a clause that's often in there that says, look, if the building burns down, if the power goes out for a week, that kind of thing, your obligations are suspended until that situation outside your control is fixed. Sometimes there are notice periods. My first legal job was reviewing a company's cabinet, filing full contracts with their supply agreements when the Longford gas explosion happened in Victoria to work out which contracts they actually had to formally go through a notification process to say we can't get product to you because the factory can't work because there's no gas. So again, if sometimes that might be regulatory changes, that kind of thing, that they offer useful protection for you. There'll often be formal dispute resolution procedures if there is an issue to follow, escalation to the CEO or senior management, that kind of thing. If things do go wrong, you can trot off to court often, get an injunction. That's an order where the court says, look, you've been using that confidential information for unauthorised use, stop it. That's a court order, you need to comply with that, else you're in contempt of court and good fun stuff. Damages is another one. If you breach your contract and the other party suffers loss, then you're on the hook potentially for the loss that they've suffered. And your insurer may or may not pay out depending on the circumstances. And one of the biggies is actually a reputational damage and relationships that suffer if the contracts aren't complied with. But again, if you've taken that effort at the beginning to talk through some of the key issues, to think about what you're putting in, what you're doing, what you're trying to take out of it, a lot of this hopefully should never be an issue. And again, if you're managing your contracts well along the way with your relationships, hopefully you don't actually have to come back to a litigation lawyer and say, oops, actually, it looks like we're going to go to court, because frankly, I wouldn't want to wish that on my worst enemy. If you can stay out of the courts, do it. And that's, sorry, I feel like I've skimmed through that very quickly, but Nadia, Julia, David, who unfortunately is not here, these guys know exactly who to turn to. They know sorry, Monica as well, who's here on the other legal side of the fence. But these guys know who the right person is. They know when you need a patent attorney, when you need a lawyer, if you need a commercial lawyer or a litigation lawyer, all of that stuff. So anything related in that way, please go to these guys and they'll help you out. I've done it. Just in time.
Thank you very much, Catherine.